All right, we're back at Senate Judiciary, January 20th. We're now picking up S208 for discussion and markup, and I believe some updates as well from left counsel. So, sorry for the course.
Good morning to Peter Downey for Legislative Council and Hillary Chudder-Ains for Legislative Council. So when we had met last time to discuss the bill, we had talked about there are two bills that have Vermont to be looking at in terms of anti-masking bills, and one is in California and one is in New York. And the bill S208 more closely tracks the New York version, but the California bill went into law last year, was signed by Governor Newsom, and became effective, or was scheduled to go into effect January 1st. And I had mentioned last time I was here that there was a hearing scheduled for January 12th. And I just wanted to give Hillary an opportunity to give you an update on the status of the California case.
So I think there was a question last time about whether the California law had gone into effect on January 1st. And because of the federal government challenge, the parties agreed not to enforce it until the court rules on the preliminary injunction motion. So it is not currently being enforced. The court held a hearing last Wednesday, and the parties expect the ruling at some point, I think in the next 3 to 4 weeks, but it doesn't mean it's So that decision would provide the most recent, similar on point judicial opinion on some of the supremacy clause immunity issues. So something to look out for and we'll keep an eye on it.
And just to refresh the committee's memory, generally speaking, can you highlight what the main issues were in them seeking the injunction and the lawsuit?
So as Professor Bowman-Posen mentioned last week, one of the core issues from a federal perspective is supremacy clause immunity, both intergovernmental immunity and this idea of discriminating against federal government actors. So the California bill does not apply to all law enforcement actors operating in California. It, for whatever reason, excludes California state police officers. So one of the strong challenges in the federal case challenging the California law is the idea that it is discriminating against federal law enforcement officers and treating them differently than at least California state officers. The other issue, the other kind of aspect of supremacy clause immunity would be a similar analysis to some of the challenges in S208.
So, I saw Senator and then Senator Noyes.
Your question was my question.
Okay, that's it.
So Hillary, you may have mentioned it. What's the status of the New York bill right now?
The New York bill hasn't passed yet. It's still in committee in New York.
And how similar is that bill to this, you know, or?
So I had handed out a chart last time that compared California bill, the New York bill, and S208. I can certainly send you another copy on that.
Oh, yeah. I can't find your way. Produce it.
That might be in your file.
Okay. Thank you. 4
Yeah.
Senator Brewer.
So this is, I think, implied by what you just said, but so the discrimination would not apply to this bill, or seemingly would not apply to this bill because it's covering all law enforcement officers. Thank you.
And if we were to do something along the lines of what was mentioned by Commissioner Morrison, where we go the route of the Law Enforcement Advisory Board creating their own set of rules for state, local law enforcement, and then us creating our own separate statute for federal law enforcement, is that something that could run the risk of a lawsuit?
I would say that would be problematic. I think it would make you want to just treat all the law enforcement officers the same. So it might be possible to have a statute that would cover all state, local, and federal law enforcement officers, and then separately have the law enforcement advisory board and the criminal justice council develop policies for statewide policies.
And also just to clarify, I don't want to misrepresent what Commissioner Morrison said. I don't think she explicitly said that we should create something for federal law enforcement, but that's, so I think she was just referring to state and local, going to the LEAD, clarify that.
And I think Professor Bowman Posen testified immediately after Commissioner Morrison, and she emphasized in her testimony that you should do all three together and not separate from that.
Anything else for planning council when we talk further about what, if anything, you want to change? So who wants to go first on their thoughts on this bill in general? I will get some ideas out there. There's a couple of pieces that I want to change as well. And as a group, that's how you're going.
So if I could jump to page 3. And I think I flagged this first time around. I fully confess to being a little paranoid about the way the federal government may respond. I think in general, they have tended to take any challenge to their authority and respond in ways that are often completely disingenuous. For instance, declaring a fentanyl-related emergency as a pretext to send officers into random cities around the country. So when I look at page 3, line 14, there's an exception for law enforcement officers who participate in active undercover drug-related operations or assignments. They may use personal disguise when necessary. I'm just wondering the freedom with which the federal government declares, let's say fentanyl-related emergencies as a broad brush way to allow different uses of power. Do you think that language is sufficiently tight? I understand the intent is to protect individual drug-related operations. Could it be broadened out at the federal level by them saying all ICE agents, all Customs and Border Protection, all federal law enforcement officers are operating essentially undercover in drug operations?
The federal government can argue whatever
Sure.
they choose to argue. In terms of tightening up the language, I mean, one possibility might be, having some language regarding that there's some, judicial approval or something for an officer to be undercover. I don't know how burdensome that would be there on our law enforcement officers, but I know there was also concern just around undercover being related specifically to drug related operations. There was concern that was too narrow. So
Well, yeah. I'm not seeking judicial review. I think we would probably hear from law enforcement that would be burdensome. But as I look through the list of exceptions, that's the one that seems to me most likely to be pried open and rendered, an excuse to get rid of the whole bill, basically. So I will think a little more about that.
I think in response to that, I think there is, and you can hear from law enforcement to see if this is doable, but making it so that law enforcement officers who participate in the Vermont Drug Task Force, that I think would narrow it without discriminating against the federal government, because there are, there's the FBI and the DEA and ATF that, have their embedded people for the Vermont Drug Task Force. So there's interstate cooperation there. And the task force is a broad and sweeping group that includes, every officer.
That's how
So,
I think.
yeah, I think we can put a note there, and I'll reach out to get some temp on it.
So I got a quick question. So as long as we're on the same page here. under D, line 17. Did we ever come up with a process for this in reference to the commissioner specified civil defense, technical defense, whatever else? We're come up with a solution to that yet, or?
Yeah, that's on my list of things to talk about here. Things that. Yeah, I think we can, since we're already there, just talk about that now. I think that what was your question? Did we figure out the process?
The process, because she had said that now, I don't think these were the exact words, but we're pitting, well, that's a law enforcement officer going to another law enforcement officer, you have to start the tickets, and here you go. She's wondering how that'll work out at the local versus special levels as far as, you and people are going to work together, and if you're on any issue. So there was concern that it's what she says.
Did Ledge Council want to respond, or did Senator Bowles-Lee?
You don't first.
I just wanted to add something, was that I did receive clarification from the judiciary team, obviously far more familiar than I am with the laws, that if you want to make it a civil violation, we would need to change the language that by pulling it a fine, that makes it a criminal issue. And I know that had been an issue whether you wanted it to be civil or criminal, but if we want to do civil, then we would need to just change the language to call it a civil violation or a fine.
Yeah, at the moment, I think civil is fine. I know there's some stuff we still have to hash out there. But Senator Bowles-Lee.
I seem to recall, and I think it was the constitutional law professor making the case that actually criminal fine would be more defensible. But I may be remembering, but I seem to recall, because I had asked a question about that. Or maybe that was the solution to the civil fine being pitting law enforcement against law enforcement.
That's what I have. I see that civil actions would be considered the same as criminal actions.
I think I challenge. The notes that I had for that section simply say criminal plus.
Yeah.
Instead of really, I'll reach out to the professor, but I feel like I recall her saying something along the lines of that being somewhat more defensible, but let me reach out right now.
What I recall her saying was that the thought that you could avoid creating a sort of federal issue around it because it was criminal and maybe going down the civil path was better, was that, you know, the understanding I had was that it wouldn't make a difference. Like the federal government would still, would have the same arguments around criminal penalties, around civil penalties.
But even if it's still, my question still remains, the enforcement portion of it. How does that happen? How does that transpire?
Right. I think that's one of the challenges, is how is it going to be enforced against federal law enforcement officers?
I mean, my thought is it would be enforced the same way ticket or a underage drinking ticket or any ticket would be enforced. The officers will have discretion as to, whether they want to issue a warning or if they're going to, very aggressively enforce this. The same way they have discretion if they want to write somebody a traffic ticket for going 5 over or not even bother putting in the first place. So I think that it leaves a lot of room for discretion for the officers who may enforce this. And I'm sure there's different perspectives on whether that's good or bad. But I guess that's just my general response to that. Senator Maps.
Yeah, I'm just thinking like process wise how this works. So you have, let's say in this case, you have ICE going in, they have facial coverings. Who writes the ticket? Who enforces this bill?
Would be a state, local, or deputy.
Yeah, what I'm saying. What's just a
Well,
I mean, it would be the
just like any
state.
other crime, that's
Somebody speeding on the interstate, there's no cops there. It'll happen.
but the way these things have tended to go in other states, they draw protesters, they draw crowds, they draw local law enforcement who are there as well as ICE agents. That's the situation where I could see this coming into play, where, there is, public expectation that this were to become law would be enforced by the local, the troopers who are there. So,
The things I have circled is to deal with the declared weather emergency aspect and that potentially being too narrow.
Yeah, I was about to get to that there. One piece that, at least for now, that I want to strike out just to reduce complication, based on what we heard from Commissioner Morrison and Director Raquel, is on line 18 and 19, the officer using their professional licensure or certifications. Given that traffic tickets generally don't make it to the misconduct hearing or the misconduct level, but I do think that there could be a component where we require the LEAB to come up with a statewide policy to address potential licensure issues, misconduct issues, because that way we still are able to create something that's enforceable sooner rather than later, but also if there's, since it was raised that there's an issue regarding how they would address licensure issues. I think leaving that specific component in their area makes sense for them to work on. Yeah.
Not really a particular concern. I think that this type of behavior should be considered the grounds for misconduct.
Yeah, I don't necessarily disagree, depending on what the context of the offense is, but I think that traffic tickets or the equivalent, the civil fines, those, as we heard from the Director Raquel, those don't generally cause the initiation of a misconduct review for the officer. And so I think that requiring them to create a statewide policy, which it sounds like is what they're doing, creating a statewide policy to address that, then I think that gets to the part of the issue for the misconduct piece.
I guess I feel sort of the opposite, that because if we stay with civil penalty, it wouldn't rise to the level of misconduct. That's all the more reason why we should put it in here, that they should consider it as such.
Yes, and I think that they probably have. I mean, the issue is you don't have the knowledge of how the misconduct process starts, how they do their investigations, how it gets initiated, so on. I think that is probably warrants a different testimony, but yeah, that's my.
And am I right that as currently written, this is a criminal penalty?
It's a civil offense.
Okay,
If it were criminal, then it would initiate a misconduct.
yeah,
Written as criminal, but I think the intent is for civil. We just need to change the language around one fine.
that was my second question. Have we decided to make it civil?
That's how we started off, and
I'm hearing Sophie saying it's now criminal.
Well, just through, because I didn't know that if you use the word fine, then it's considered criminal. If
Yeah.
you want it to be civil, then you have to say it's a civil penalty.
Yes,
So it's more just the language thing, but I understood the intent to be that it be civil. It was just the current language would make it a fine.
just for what it's worth, I like the way it's drafted now. My worry about this is that ICE has been exceptionally well funded by the big beautiful bill. They're offering $100,000 to agents and a $40,000 signing bonus, which is astronomical. And so I imagine that if we're talking about fines in the hundreds of dollars, it wouldn't have a lot of impact. So I prefer the way it's written rather than moving to a civil penalty. And also the change around, directing a statewide policy to be written later, I like this language better in both cases.
So, just so I'm understanding, the preference for you is to keep it a criminal offense?
Yes.
Senator Hashim, one note on what you and Senator Huxley were just talking about. The statute lays out the kinds of misconduct that trigger the Vermont Criminal Justice Council to undertake proceedings. So Director Burkell had mentioned that one of them is a felony or certain misdemeanors. The second one is willfully failing to comply with a state required policy.
Okay.
So to your point, if the LEAB were to put forward a policy, non-compliance with that state required policy would then become misconduct within the meaning of the statute.
Got it. So then can we just cross-reference that in this?
Yes.
Yeah, okay.
Whether an explicit cross-reference is necessary or not, we'll look into, but affecting that policy change would have that impact based on the other provision.
Okay, then, I mean, if a cross-reference is helpful, I think adding that, instead of just saying, they'll lose their professional licensure certification. I think making that cross-reference that it will initiate the misconduct proceeding or investigation, based on what you had just described, I think that could be a good start.
That's 20 VSA 2401. Or reference.
As category A, category B, and category C conduct, and this would be category B.
I think I saw some battles first.
I'm just continuing down this line. Doesn't that kind of run in when Commissioner Morrison was in? She talked about, having that path to the LEB and the Justice Council. Wouldn't this put us back on that track of being on the same road, but two different lanes? Because one would be criminal and it would kind of overarch over what the LEB and LEAB, the Justice Council would be doing.
I think that the potential cross-reference is not just for crimes, but also includes state policies. So potentially like a traffic ticket, or in this case, this ticket. If I'm understanding your question correctly.
But if it's criminal, it wouldn't then go to the courts. It wouldn't go to.
Right, it would go to the courts. I mean, it would also likely initiate a misconduct investigation.
So I'm curious how that interplay works when you have two different paths on the same road.
Reality is this would apply to the state and local law enforcement officers. This isn't really going to impact.
Right.
Well,
So,
I think it will it's nice that we're all sitting in this nice warm little office here and we're talking words on paper, and the comparison of writing a ticket to a 17-year-old who's possessing alcohol or consuming alcohol is not the same as asking a Vermont law enforcement officer to either issue a citation or a ticket to one of their federal partners. My concern is that being on the Canadian border, I've heard, have worked extensive hours with our federal partners as to, okay, so you just arrested one of our guys. We depend upon these individuals, these professionals to respond to our instance, in case of backup purposes. I'm just wondering if we're going down a path here that we may regret.
It's a fair point. I would just respond by saying, in my opinion, we're not the ones who are straining that relationship. It's the federal government that is straining the resources and patience of all their partners across the country. So I think your caution is well taken, but I think in large part it's for Kristi Noem and President Trump, who are deliberately making Customs and Border Protection and ICE, they're forcing them to become irritants in communities to produce, in my opinion, a certain level of chaos that will then mandate increased force. So now we're talking about, active duty military being sent to Minneapolis. That's not the fault of local officials who are trying to preserve their authority. If I might, Mr. Chair, I have a question about page 2, line 14. I like this language. I'm wondering if it means what I think it means. The law enforcement officer shall not wear any mask, that's what we've been talking about, or personal disguise. And I think ICE in particular has a documented history of adopting local law enforcement, police identification, when they are not local police. Would that, trigger this piece, the idea of personal disguise, if they are, willfully representing what agency they represent?
It certainly could. I think the other piece is, paragraph 1, C1 of that line 12 is really, again, going back to the identification of the officer. So, making sure that they're identified. And again, there was, testimony around including agency, which is not currently included in this bill. But being clear what agency you're from, we make it much harder for a nice officer to pretend that they're with the, Williston Police or whatever.
Great.
There is also one additional piece to that. I can't find my notes here, but on line 50, I believe this came from Commissioner Morrison, which was instead of interacting with the public, make it so that it is in the performance of their duties. Was justified.
Are you on 2?
Yeah, page 2.
I'm 14.
Yeah, 14 to 50. Anybody else remember her saying that?
It does say that. It just says
Interacting with the public.
in the performance of the officer's duties. Says both.
She had suggested adding unique radio or badge number
Yeah,
Above.
to, yes.
I have that note. Well, I wrote it as call number, but, and then adding agency. On line 1, C1, page 2.
Okay.
But C2 already does say, I mean, I guess if you strike while interacting with the public, it's broader. It would be in performance of all of their duties, whether or not they're interacting with the public.
All right, perhaps I'm just misunderstanding. Okay, so yeah, let's scoot back up to section 1. Adding name, badge number, or radio number.
Unique radio number.
Unique number.
And then the agency. I also think it shouldn't be or, it should be and. I think it should be the officer's name, their unique identifying number, and agency.
Yeah, I don't know. I mean, I think badge numbers change. It's there are different radio numbers as well, and it's I feel like name and agency is the most useful way to go about it. But that's my opinion.
Yeah, I think that I'm happy to have that conversation, and I think I could be swayed to agree with you. I'd probably want to gather a little bit of my own information, but as it reads now, it's named or. And I don't think so I guess it could be named for that or unique number and agency, but I don't want it to be just one of those 3 things. If that makes sense.
Yes.
Okay.
Do you have any thoughts on how we clarify this line 12 to 13?
Have any thoughts on how we might clarify this language?
It'd help us wordsmith here.
Yeah, I mean, you could have a law enforcement officer shall be clearly identified by the officer's name or the officer's unique radio or badge number on the officer's uniform and the officer's agency on the officer's uniform. So they're always required to have the agency, and then again, depending on what the committee wants to do, if they want to have a badge or name both in the first part.
I think that works. The way you just described it.
Are we done with that language?
Center
I actually got one more on that realm. I remember hearing, I don't know who said it, but there was the when safe to do so language. I don't know if that was federal or was it?
Yes, that was so under federal regulations for ICE officers. They're required to identify themselves, and then there's that language around when safe to do so.
But their argument basically is that it's not ever safe for ICE because they'll be docked and, you know, et cetera. So I just don't think there's any good faith use of that phrase at the federal level. I think they will just argue it's never safe for them.
One distinguishing factor, though, is that this doesn't require verbal,
Right.
of a verbal identification necessarily. If you've got it on your uniform, you do the same thing, is my understanding.
Cause I'm just thinking about how that interacts, you know. Vets have something on the books that says when safe to do so, identifying yourself. How does our state statute interact with that?
And that's basically the question of the whole.
Right.
Yes.
So I just saw my other question, but I think in response to that, and do correct me if I'm wrong, but my understanding is that that language is around if you're making an arrest, you need to identify yourself when safe to do so, and this would apply all the time. And I don't think they really interact at all, because this says you need to have this displayed. And if the federal immigration officer is making an arrest, then they need to verbally identify themselves when it's safe for them to do so.
And that's
But-
what all things.
Yeah. But I think it's in that if ICE is walking around the street, is that our issue, or is it when they're making that arrest?
I would
think-
say if they're walking around masked and they're in performance of their duties, they're in contravention of this.
If they're not identified.
But it doesn't negate the federal requirement that if they are making arrests, they say, I'm officer so-and-so with Immigration and Customs Enforcement, and I'm, making this arrest.
Like I'm thinking about how the 209 is written about safe spaces, and you're on your way somewhere. If there's an ICE agent or whoever on their way to go somewhere to arrest, is it when it's safe to do so that they have to identify? I guess that's just where I'm.
Well, the mask piece says interacting with the public in performance of their duties, but the piece above just says clearly identified. So I take that to mean if you look out on the lawn and there's an ICE agent standing there not doing anything but their mask, then this comes into play.
What if they're in the process of an arrest? Gonna be going to.
This to me doesn't hinge on whether they're going to arrest. It just says they shall be clearly identified. So when they leave the barracks, they should be clearly identified. One way or the other.
But then that interplays with the federal statute where it's when it's safe to do so in the process of an arrest. But if they're
Prohibit them from that, though, right?
well, if they're on the way to do it, is what I'm getting at. Like, at what point is the arrest on the
I
clock?
think just speaking to ICE agents in the community, mass, and the terror that is causing. And I would say deliberate fear and terror that it's causing. And this is meant, as I read it, to push back, not just on that specific moment where they're forcing their way into a home or a car, but they're out walking around. And that walking around is meant to habituate Americans to law enforcement agents on their streets. So I think it's written broadly and should be, at least from my opinion.
One clarification on the federal
Yeah.
language. It's a federal regulation and not a statute, which is important.
Mm.
So it's not the status of a federal statute, even potentially conflicting with a state statute. And the language is at the time of the arrest.
At the time.
The designated immigration officer shall, as soon as it is practical and safe to do so, identify himself or herself as an immigration officer who's authorized to execute the arrest. So that may help us.
Yeah, and I'm all like, just trying to figure out a process of how this would actually work is what I'm trying to get at.
So we were discussing that before because it was coming up with this supremacy clause immunity. And so the test for that is really asking, is there a direct conflict? And right now there's no federal statute or officially enacted policy that explicitly authorizes or requires masking by federal officers. And then officials with the Department of Homeland Security have publicly said it's up to the individual officers whether they want to or not. And so at the federal level, there's the National Defense Authorization Act we talked about last time, which I did do a bit more of a deep dive on that, which was passed in 2020, went into effect in 2021, and that was after all the George Floyd protests. And that requires federal law enforcement to visibly display their identity and the name of their federal agency when responding to a civil disturbance. And you'd asked about a civil disturbance, and that is not defined in the statute. There is some Department of Defense sort of definitions of civil disturbance. And then the other piece was that ICE offenses we talked about are required by law to identify themselves at the time of an arrest, and that's again in the regulation of the statute. So there's no direct conflict between what this bill proposes and federal law.
Well, weather question.
It's the full weather question, and I'm not entirely sure how to wordsmith that, but the other pieces that I remember and I have notes on was the medical grade mask that is surgical being too broad.
Yeah.
I also recall, Commissioner Morrison suggesting we add an intent section or change the language to be very explicit what we are trying to prevent.
Yeah.
And the other suggestion I would have would be to make it effective on passage, not July 1st.
I think my thoughts on that regarding the subsection A and subsection B, medical grade mask with the surgical versus the N95 respirator used to prevent the transmission of airborne diseases. I feel like if we have B, we don't really need A, because the whole purpose of B, the whole purpose of wearing those masks is generally so that you're not spreading diseases.
I might
So
suggest that it perhaps get changed to read an N95 respirator or medical grade surgery mask with the intent to prevent the transmission of airborne diseases.
Well, we're not quite sure how we're gonna, just to follow up on the question, I want to make this effective upon passage when criminal justice council is, they don't have a policy.
No, it's not on passage.
Well, no, I'm suggesting that it be on passage. I think the terror that's happening can't wait until July to be solved.
Ordinarily, I would agree. I think this probably wouldn't get signed if it does by the governor before end of May. So that gives them about a month to bring into play this policy. So I don't think that's a long time. That's a relatively short time for them to communicate this to their people. So I could support the way it's written.
We also have a later date for passage of the policy, because I know there was testimony around it being anywhere from 6 to 9 months, it sounded right. So you could have the law go into effect, but the policy itself, the statewide policy, go into effect January 1 of 27 or a later time.
I could certainly support that. I imagine, given that we heard from the Criminal Justice Council are already in conversation about this policy, that they can communicate this information while the bill is still in process. And I just think the level of fear and concern really necessitates as quick of a response as we can manage.
What does everybody think of that sort of timeline, creating the two effective dates?
Sure.
so with the LEAB and
LEAB would be later on so that they can develop their policy regarding any misconduct.
yeah,
And the enforcement provision of the $1,000 traffic ticket would be on passage. That's my understanding.
Okay. So back to your point, sorry. Okay, back to your point. Did you just want to combine A and B? Is that what I was hearing?
So I think that basically
Okay,
it's a combination of A and B and a shift from design to content. And I think that was all of my notes on things that would change. The one point that I don't think we really talked about that I do think is important is that in many ways, I've now been made aware of 3 different instances where non-law enforcement has masked and impersonated law enforcement to commit crimes. And so this bill to me also protects law enforcement from being impersonated because they're clearly identified as law enforcement.
So regarding,
It's just there's nothing that needs to change. It's just
Yeah.
a statement.
regarding the medical grade mask and the N95 respirator, I could get behind the adding language that says an N95 respirator or a medical grade mask with the intent or worn with the intent to prevent the transmission of airborne diseases. I think that clarifies it a bit more.
I don't know how we'd ever prove intent, but I mean, I don't see any problem with putting it in, but basically the language we have now is just if you wear these things. If we get into what the intent was, I don't know, it just doesn't seem necessary.
But if we make it a criminal statute, you only have to prove intent and or knowingly provides. Or charge someone criminally because there's enough to something to prove intent.
If it was criminal, then yeah, you would have the mens rea. It is civil though. So
We made that determination, I'm sorry. I didn't say that.
Well, yeah, we haven't
I heard
yet.
different discussions on that.
We've come to that a couple of times. We haven't
Yeah, we
yet
have.
voted on whether that.
Yeah. Yeah.
Curious to your point about difficulty proving intent, and I think a lot of times when we put things in language, generally most people will follow it because it says it. And when it just reads that there's an exception for these masks, if that are designed to or for any reason, including, masking or disguising yourself. And I think that when we get to the sort of LEAB portion where there's potential misconduct, they would do the investigation too. So I think the language is important. And I think most good actors are going to follow it as it's written because that's what it says. I'm actually saying I think all the actors are going to read it.
These changes aren't necessarily going to be the final product. It's just trying to move along with this. And, we can get some new language, think on it, and then come back to the same discussion. I think that one thing that appears up in the air is whether or not it's going to be criminal or civil. That still seems to have some uncertainty.
And then I think that's just some language changes to shore up some of the exceptions.
Yeah, there is on page 3, there's the cold weather exception. There are plenty of instances where there's not necessarily a declared weather emergency, but if you're on search and rescue looking for a long hiker in January, probably going to want to wear a mask. But at the same time, I don't want to create an exception where somebody says, but yeah, it's 55 degrees out, it's cold, so I want to wear a mask. So I feel like there has to be some middle ground there. Yeah.
I do. It's actually for Senator Baruth. You had brought up I'm having a hard time finding the thing you brought up about undercover
That
Right.
page 3, line 14.
things. Because I think you had suggested we change it. You had a way to change it. It was operated in
Vermont drug test, please.
Sky. I'm just trying to make notes for myself.
And we can get testimony from one of them, regarding whether that, making that bank allows them to continue doing their job without necessarily granting this broad, exception to address some of these concerns. For lead council, I'm wondering if you have any thoughts on how to reword lines 7 and 8 to make it slightly more broad, but not too broad. To the point where anybody, any officers wearing a mask, if it happens to be below 70.
Could we use the same language as is used for cold weather exceptions for like housing? So, you know, there's a state, maybe you don't, but there's a state.
I could look it up.
I wonder if we could use that same language, because we have said in that instance that the cold weather exception applies to get people sheltered. And then also maybe add in some stuff about like length of, like search and rescue and length of time. But that's not as bad as a declared weather emergency, but it is, or it doesn't, it's not the same.
It's a different emergency.
Yes, but I think it's actually like there's certain temperatures where
Yeah.
that's the cold weather exception, and it's a lower bar than a declared weather emergency. Just a thought. I had a momentary stroke of genius.
Yeah,
But I know what the language sounds like. Never let your council find out.
you declared, I've been there quite a long time. I don't know how often we have
Yeah.
declared weather emergencies.
I remember one
Other
cold
than
weather when I was in 7th grade.
right, other than something like tropical storm, I read, but I mean, not in terms of cold.
1998, that's when.
That's when I was in 7th grade. That's the one I remember when I was in 7th grade.
So, so you folks will be able to do some research into potential wordsmithing there.
Yes, I can certainly look at that.
Did anybody else have any other thoughts on that particular site? We, let council, could we just go back to the list of what you have for now for proposed changes that we agree on? I know it's been kind of scattered, but
So, on page 2, lines 11, 13, adding in, the agency and then adding in the unique radio badge number. I still have it as an or, but I know that was a discussion of whether it was, should be an and in terms of the name and badge number. On that. So that would be 2 prong, that you have to always disclose your agency and then you can do either name or badge radio number. Okay. And then under the bottom of page 3, lines 19, 20, bringing those A and B together as N95 respiratory medical grade mask warned with the intent to prevent the transmission of airborne diseases. And so then that would change the numbers for those, so that would just be combined to those 3. F on page 3, lines 7 and 8, we'll look into whether there's some other language we can adopt for the housing. And I've got comments on the other things. I've got specific changes other than getting into the penalty, deleting out the reference to the Office of Professional Licensure or Certification. And then, so right now it would say, section should be fined not more than $1,000. But again, we would need to confirm what the intent is there. That's, as it's written right now, it would be a criminal. We wanted it to be civil, that would need to change. And then on the section 2 at the bottom of page 3 would be that this will take effect on passage. And then we would be adding in language around asking the LEAB to develop a policy around, professional misconduct violations of this statute, and then we'd be giving them further time.
So the other thing I had was on page 3, line 14, the language around working with the Vermont Drug Task Force.
That, yeah.
And I'm not. I'm trying to track the conversation because it's been a little all over the place, but I thought there had been some different conversation about the misconduct piece. I wasn't entirely sure that we had agreed to take that out.
I thought we had deferred the question of civil and criminal, but that the chair had proposed immediate passage for the fine and then a longer timeline for a statewide policy to come out of the LEP.
Yeah, to address how, they would initiate a misconduct investigations.
Yeah.
I think that's also to develop a statewide policy.
Yeah.
Okay. I guess I would just want to be fairly clear with the language around the LEAD that the intent is that it would trigger,
Yeah.
would trigger misconduct, like,
Not that they examined whether it should.
right. But that they determine how to do that. Okay. I think I can move that.
Yeah, I think so, because I can, realistically, I can't imagine that, if it's, I don't know, I mean, officers are gonna have a lot of discretion, and I think it's gonna be a big step to actually write this ticket. And so having the requirement that it will initiate misconduct investigation, I think is unreasonable. You may want to hear from Director Kelligan.
And this is part of why I have concerns about it being civil and not. I mean, I have a lot of concerns, but I think, well, I think we could give us that at a later point when we come back to that point. But I think the point you're making about it being a big step for this to be enforced gives me pause.
I think it would be a big step because I expect everybody's gonna follow the law, so that's something that break it.
Well, there is discretion.
Exactly.
I could say by professional discretion, application. I mean, in some ways, we're pushing back against a much larger, more powerful force. And, I take comments that are made seriously that local law enforcement officers are put in a tough spot and everything. But again, I don't think it's a situation of our creation. It's maybe deliberately fabricated by the federal government to test all of the relationships. So,
Well, I think just have to think on criminal versus civil a bit more. Then we can revisit that conversation. So let's put a pin in that one for now.
I did a couple of other notes. I just wanted to check with the committee. So, I think this was from the testimony of, Professor Norman Posen was adding legislative findings.
Yeah, that was the last thing.
Okay, and then she had also suggested that, at the bottom of page 1, this talks about, the General Assembly to exercise the power granted to Vermont by the 10th Amendment, and she said that Vermont already has that authority, so to reframe it as essentially recognizing that we already have that authority.
Yeah, I'm definitely interested in adding some additional legislative intent. I think that is a much more broad and subjective conversation as to, rather than specific policy choices. I did get several paragraphs recently from a civil rights attorney in Rutland, I believe it was Rutland, that I could share with the committee, and we can discuss whether or not we want to move along with that. Any other thoughts on legislative intent general?
I would say, I'm not opposed to intent. I think findings, the House is very enamored always of findings. I just feel like every sentence of findings generates, a lot more resistance than the actual, prohibitions of the bill. I like that this one goes light in that area. It's editorialized.
I agree with you in part. I think in this situation, findings or intent is, it can be used in litigation. And so, if there was intent that said, got a big problem with the federal government, we're going after them, that's obviously going to be used in a lawsuit. But because you can't discriminate. But, if we had findings that is geared more towards policing generally within our jurisdiction, within the borders of Vermont, and how we want that conducted under the 10th Amendment. I think that is an important distinction.
I just think the intent language as it stands already does that. Then,
I wonder if, so the constitutional law professor had indicated that the language as it is now does not adequately do that. And I wonder if she might be willing to kind of work with us to craft something that is narrowed. My understanding from another bill I'm working on is that the Senate does rarely do findings and intent, and when they do, it is specifically sort of aimed at this type of situation where it might land in court. And so I wonder if she might be willing to work with us to craft something that is narrow but meets the need in this instance. Because I also had that note about finding an intent, and I also remember Commissioner Morrison indicating somewhere in here, maybe it was in the intent section, that we should be more clear about what it is we're trying to prevent. Right.
In regard to the legislative intent, what I can do is send this to all members of the committee, and then also request the professor wants to weigh in. And the committee can look at these 10 paragraphs, see, so what changes we want to make, then we can revisit it at the next markup. When we get these changes back, we revisit some of the other differences. Any closing thoughts? Or last minute changes that we have? All right, sounds good. Thank you. Let council will find a time next week. Get back.
Very much.